Good morning, ladies and gentlemen. Thank you.
Afternoon.
Afternoon, I should say. Thank you very much for inviting me, Iram, to talk about GDPR update. For those of you who don't know me, my name is Ibrahim Hasan. I'm a lawyer and director of ACNO Training. We've been in this space for over 20 years now, and we're very pleased to work with the IRMS. We exhibit and often speak at the conferences as well. Looking forward to the road shows. And I think I've been with the IRMS in terms of working with them probably since I've started in 2002. So we deliver training and consultancy on all aspects of data protection law. I'm sure you're well aware of us, or you can read about us on our website. So are we ready to start then, Iram?
We are. So I'll do a quick introduction to the IRMS and then we'll get going. So I'm Iram Ditter and I'm the IRMS Legal Group Chair. Thank you all for joining today's session. We're bringing to you Ibrahim, who will talk about the latest GDPR news, including enforcement actions from across Europe, as well as the progress of the Data Protection and Digital Information Bill. This session will be recorded, and it is being recorded right now, and will be available on YouTube within about 2 weeks. And those of you who are joining us who are members of the IRMS will receive an email notification to let you know when the recording is live. If you have any questions during this session, please feel free to use the questions section at the bottom of the screen. It's right underneath. You'll see questions and chat. If we keep questions to the questions section, it will allow me to push them to the screen for Ibrahim to answer. Feel free to chat amongst yourselves using the chat section. And I think we're good to go. So I'll hand back over to you, Ibrahim.
Thank you very much, Iram, and good afternoon, everybody, to this GDPR update. Lovely to see so many people here. I can see some old faces or old names that I know. 84 people online. Hopefully some more will join us. So as Iram explained, lots has happened in the world of GDPR. In the world of data and privacy, lots of developments in the last few weeks, lots of stories that have hit the headlines. You'll have read about over the summer the Police Service of Northern Ireland data breach, where details of more or less every single police officer in Northern Ireland were actually disclosed as part of a Freedom of Information request, and that caused a lot of obviously a lot of upset and upheaval, and the Information Commissioner is investigating. Of course, Nigel Farage can never be far away from the news, folks, as we know. And recently he's raised the profile of data protection, in particular subject access rights. We've had developments in the world of transfers to the US in particular, and lots of other things. So hopefully in the time available, I'll be able to cover some of those and also take some of your questions as well. Let's go straight into it then. Let's look at some recent cases and fines in relation to the first principle. The first principle, of course, you're all aware, data must be processed fairly and lawfully and in a transparent manner. In terms of lawfulness, of course, we have to comply with the general law, but also we have to ensure that whenever we are processing personal information, there is a legal basis for processing. Apart from consent, there are a number of other conditions that you can rely on to process information. And in this fine issued by the Irish Data Protection Commissioner, Ireland, of course, subject to the EU GDPR. We in the UK, we're subject to the UK GDPR at the moment. There aren't many differences. Going forward, they may be, depending on what happens with the Data Protection and Digital Information Bill, but more of that later on. So let's remind ourselves of the conditions then, which are, if you just bear with me, here we go. The conditions within Article 6. Hopefully you can, oh, yes, Article 6 then, processing is necessary for the where we have consent, but also for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into the contract. So some organizations are of the view that any contractual arrangement with the individual, whose information you are processing leads to this contractual condition being engaged. Well, this case involving Meta actually tells us otherwise. So this relates to Meta. They were fined £210 million and £180 million by the Irish Data Protection Commissioner. And this was from December 2022. The fines were imposed in connection with the company's practice of monetizing users' personal data. What happens is when you're on Facebook and Instagram, your details are shared with advertising companies who then advertise directly to you. Your profile, your information is sold to these companies. So your digital footprint, what videos you've watched, and everything is used to profile you, and that information is used to then serve up personalized adverts. The DPC, Irish Data Protection Commissioner, received 2 complaints from Facebook and Instagram with regards to Facebook and Instagram by a campaign group called None of Your Business, headed by the one and only Max Schrems. And they questioned the legal basis upon which this information was being shared. Now, previously, Meta would argue that they had the consent of the individuals, okay, because you've accepted terms and conditions and you have given your consent to the sharing of information. But of course, there are concerns about that as to whether the consent is freely given, specific and informed. So a while ago, Meta changed their terms and conditions to say that they're relying on where processing is necessary for the performance of a contract to which the data subject is party. And they said that, well, we need to share this information because by sharing this information, we are able to generate revenue, and as a result, we are able to provide individuals with access to Facebook and Instagram. They can post what they did over the weekend, the lunch that they had this afternoon. They can post details of that and everything else that they do. They can live their life and connect with people, etc. So we have a contract in place with the individual because when they sign up to our terms and conditions, it's already flagged to them. They accept those terms and conditions. There's a contract in place when they click accept. Okay, that was their argument. Well, of course, the consent didn't work, so they tried to argue a contract. But what did the Irish Data Protection Commissioner say? Well, they had a number of findings. We'll come on to the contractual basis. But before we do, Meta Island, it was considered by the Irish Commissioner that they had not provided clear information about the processing of the user's personal information. In particular, their privacy notices weren't clear. There wasn't clear information about who they're going to share the information with. So this led to a breach of Article 12 and 13, but also lack of transparency meant they were breaching Principle 1 as well. In terms of the legal basis, could they rely on contract? Well, the Irish Commissioner said that Meta cannot rely on the contract legal basis for justifying its processing. The delivery of personalized advertising could not be said to be necessary to perform the core elements of what was said to be a much more limited form of contract. This came about as a result of the European Data Protection Board also making representations. And the long and the short of it is that if you're relying on contract as your legal basis, then first of all, you have to have a contract with the individual, of course, but also it must be necessary to process the information in order to fulfill the contract. Here, the DPC was saying, and as a result, these Facebook and Instagram were fined, is because the legal basis that they were relying on, contract, it wasn't necessary to process the data. They were processing the data for the purpose of selling the information on for the purpose of personalized advertising. The personalized advertising wasn't a necessary part of the contract. Okay, so that's an important decision when it comes to necessity and contractual legal basis. It's not enough to say we have a contract with the individual, therefore we can process their data. And to just confirm this point, another decision involving Meta, European Court of Justice, necessity for the performance of a contract must be objectively indispensable for a purpose that is integral to the contractual obligation intended for the data subject. To the extent that if a given processing operation does not occur, the contract cannot be performed. This does not include processing that merely funds a company's business operations. There must be a demonstrable link between contractual obligation and the processing in question. So, important decision, explains the sort of contractual legal basis, well worth having a read of. Okay, feel free to ask questions as we go along. Children's information. Quick question from me to you. What is the legal age of consent, you could say? When can a child give consent to the processing of their personal data? One of the legal conditions, of course, is consent, but when can a child, at what age can a child give their consent to process their personal data? Carol says it's 18. Rebecca says it's 13. Let's see, we've got 13, 16, 12. Okay, now, a bit of a trick question there. Still some answers coming in. Mostly people are saying 13. Mark. Excellent. Yes, Mark has got it right. There is no specific age for general processing of children's information. There is no specific age. Fraser says when they're capable of demonstrating that they understand the processing they're being asked to consent to. Absolutely right, Fraser. Trick question. The 13 relates to information society services. When you are processing children's information on the basis of consent, then and it's information society services, social media, offering goods or services at a distance for a cost, etc., then if the child is 13 or over, they can give their consent. If they're below 13, then an adult has to give consent. That is set out within the legislation, within the UK GDPR. Okay, so the 13, there is no specific age when it comes to general processing, as Fraser said. If they have a sufficient understanding to be able to make that decision, then they can give consent. Otherwise, when it comes to information society services, social media, selling goods or services at a distance, usually over the net, connected toys, various online services that kids can sign up to, etc., or may be accessed by a child, then there the age of consent is if it's 13 or over. Below 13, you need parental consent. That's important when it comes to information society services, and obviously not all of you will be providing these kind of services, but when you do, it is important to bear in mind the requirements in terms of consent, but also in terms of transparency and openness as well, ensuring that your privacy policies are clear and drafted, as it says in Article 12 as well, with the child in mind. So using sufficient, appropriate language for the age of the child. And this is something that the Information Commissioner emphasizes within the ICO's children's code as well. But I think there's a wider point here, which is whenever you're processing information about children, you have to be careful and you have to ensure that you are being fully transparent, you are being fair, you have the appropriate legal basis, and of course, that the child has the capacity in order to give consent. This is the TikTok fine. I think this was April 2023, £12.7 million fine issued by the Commissioner to TikTok on the basis that they didn't have appropriate measures in place to check the age of the children, the parental consent requirements hadn't been properly implemented, and the privacy notice wasn't entirely clear. Okay, answers still coming in. Okay, I think we've answered that one. Sarah, I'll come to your question later on. When it comes to children's information, once again, another high-profile decision recently, this month in fact, from the Irish Data Protection Commissioner, a 345 million euro fine to TikTok. Specifically when it comes to children and when it comes to information society services, but more generally as well, when it comes to dealing with information in relation to children, the default setting must be very high privacy. If you're, as in this case, the DPC 345 million euro fine, what did they find? That the platform settings for child users weren't particularly child friendly. In fact, they were set to public by default, meaning anyone could view the content posted by a child user. In particular, breach of Article 25, data protection by design and by default. Breach of Principle 3 as well, data must be adequate, relevant, and not excessive. Other infringements, the family pairing setting allowed a non-child user who could not be verified as the parent or guardian. As we know, TikTok allows parents to keep tabs or keep their children safe through its settings, but there was no verification that somebody who was accessing this family pairing setting was actually the parent, so that they could pair their account to the child's account. This allowed the non-child user to enable direct messages for child users above the age of 16, which posed a severe risk to child users. So again, breach of Article 25, data protection by design and by default, and also breach of the security principle. Failing to provide sufficient transparency information, particularly relevant and in a child appropriate way. And interesting, the DPC Ireland also made a finding in relation to dark patterns. This is where systems are used to nudge people towards a particular decision. So TikTok implemented dark patterns by nudging users towards choosing more privacy intrusive options. Location setting, sharing their location, allowing their information to be accessed and shared and analyzed, and for them to be profiled during the registration process and when posting videos. There was a they were encouraged to do that, encourage more privacy intrusive settings. That was considered to be a breach of Principle 1, particularly in relation to fairness, that it was not fair. So DPC issued a reprimand, an order for TikTok to bring their processing into compliance within 3 months, a tall order for such a large platform, and a fine of 345 million euros. So when it comes to information about children, we have to be careful. Even if you're not providing information society services, which I suspect most of you aren't, you've still got to bear in mind your users. Have a look at the Children's Code issued by the Information Commissioner, because it gives you a lot of good tips in terms of what you should do when it comes to children, child users, children's information. Okay, I've got a question from Sarah. Oh, no, it's not a question. I am DPO for schools. We say there is no minimum age, but it's generally accepted that after the age of 12 a child tends to have the capacity and maturity to understand rights and give their own consent, for example, for school to release data to a parent. Every case is different, Sarah. I mean, you're not that far out when it comes to, so it depends on the nature of the information. Okay, the more privacy intrusive it is, what you're doing with their information, the more you might need to do a proper assessment of the child's understanding, or belt and braces approach is to involve the parents as well. Okay, so it sort of depends, but 12, there's a concept called Gillick competence. Does the child have enough sufficient understanding? I know it's Scotland, it's different, but yeah, about 12 is okay, but it all as a ballpark, but it all depends. Okay, Facebook was fined 1.2 billion euros, again by the Irish Data Protection Commissioner, for mishandling data. It says this was in relation to quite a long investigation by DPC Ireland in relation to the transfer of data by Facebook Ireland to Facebook Inc., or Meta as it's probably now called, as it is now called. 1.2 billion euro fine, because obviously when the gentleman on the right hand side, does anybody recognize the gentleman there? Who is the gentleman on the right? Max Schrems. Thank you, Hayley. Yes, Max Schrems, he challenged Facebook for sending his data to the US without appropriate safeguards, because of course the Privacy Shield was in effect torn up by a decision involving Mr. Schrems. Facebook had not put in appropriate safeguards as per Article 46, standard contractual clauses, etc., or if they had, then the appropriate safeguards hadn't been included. So they were fined 1.2 billion euros. This was before the EU and the US agreed the new Privacy Shield framework known as the Data Privacy Framework. This is another certification scheme. If you remember, Schrems expressed certain concerns about US surveillance laws, about the lack of redress for individuals whose data was accessed by law enforcement agencies within the US when it got there. So the UK, the EU and the US came up with this framework. It has now been approved. The EU has approved it. It means that transfers from the EU to the US can now take place. There is no requirement for any standard clauses. There's no requirement for any safeguarding, other safeguard mechanisms. There's no requirement for any kind of assessment, which is what Schrems required us to do. But obviously that only covers transfers from the EU to the US. Well, what about the UK? Well, very quickly, the UK agreed in principle back in June that they would piggyback onto this data privacy framework, but they will call it the data bridge. And indeed, recently, just I think it was last week, this was announced as having been completed. So having made a big deal about the fact that we are no longer in Europe and we are free to forge our own relationships and laws, etc., the UK decided to piggyback onto an agreement which had already been reached between the EU and the US. So basically what it means is that any company or organization to whom you are transferring data within the US, which has signed up to the data privacy framework, I should say, between the EU and the UK and the US, if they've signed up to that, then that is good to go as far as the UK is concerned as well. So if they sign up to the privacy framework, data privacy framework, then that's okay for you to transfer from the UK to the US. So that's good news. No longer do you have to worry about standard contractual clauses or binding corporate rules or anything else, or relying on an exemption. You can transfer data to the US as long as I say, you check that the company has signed up to the data privacy framework. AI and machine learning, something else as we as data protection professionals have to keep an eye out, and there's been lots of developments in this area since the start of the year. It's all about AI, machine learning, and also of course ChatGPT. You'll be pleased to hear that in doing this presentation I did not rely on ChatGPT. So AI, that's something that we've got to keep abreast of in terms of developments, folks, as privacy professionals, because of course it has a big impact on individuals' privacy in terms of how information is gathered, used and shared using AI, but also in terms of more from a human rights perspective as well. If AI is being used in the medical sector, in local government to keep us safe in terms of facial recognition and everything else, or in terms of recruitment, what are the dangers that we've got to be alive to? Well, of course, the wrong decisions. That's the first thing. In the US, AI is used to in terms of administrating Medicare or medical insurance plans, but algorithms are used. And sometimes they make the wrong decision, in which case an individual's payments are cut because the algorithm decides that they are fit to leave hospital. They should have already left hospital, but they're still there and their payments have stopped. In terms of AI and any kind of personal data which is being processed through AI and machine learning or algorithms, of course, it's also about ensuring that it's fair, lawful and transparent. You've seen the headlines there. No need to say much more about that. But again, GDPR, obviously, when you're processing personal data, applies in terms of transparency, openness, accountability, but also in terms of ensuring that you have systems in place to implement, to adhere to individuals' rights, to ensure that you respect their rights, particularly Article 22. An individual has a right to challenge decisions which are made by automated means, which have a significant impact on them, which have a legal impact or a significant impact on them. So it's about ensuring that you are involved from the start in any project involving AI and personal data to ensure that the data protection principles, the rights are fully implemented. Obviously, the Information Commission has got lots of advice in that area, but also look out for legislation in this area. The EU has produced the draft, which is currently being discussed by various parts of the EU, and then it will go out to full consultation of the countries. They are in the throes of producing legislation, EU AI regulation. Now, in the UK, Rishi Sunak said that, well, we're not going to regulate, we're not going to produce new legislation and introduce more red tape for companies and organizations. We want to encourage innovation. He said that and said that regulators should be willing to sort of step in where AI goes wrong. Now, after having been to the US, he came back, met President Biden and said that, no, we will probably end up regulating in some way, shape or form the use of AI. So I think it will happen. If Europe's done it or is in the throes of doing it, then I suspect that the EU will, the UK will follow suit as well. So just keep a lookout for this in this area. As I say, previously they said they wanted to have a pro-innovation approach to AI regulation. But I think now we will see legislation, so something to look forward to. Okay, Kiva, interesting. Yes, absolutely. What about the situation in Spain regarding AI circulating Photoshop photos of children in a sort of, yeah, absolutely. Quite worrying, isn't it? And it also, I think there's a lesson for all of us really in terms of what we post of ourselves on social media, but also educating other members of our family and our wider social networks as to what's available and what's there, and the power of AI. Absolutely, Kiva, that was quite worrying as well. Yeah. Yeah, absolutely, Steve. How can they challenge? Yeah.
We've got two questions in the question section, Ibrahim. I can pop them on the screen.
Yes.
Steve, maybe we can have you elaborate on this one. So will it fundamentally change how advertising is done?
So yeah, Steve, do you want to come in on this one?
I can invite you to the stage, Steve, or you can just pop your response in the chat.
Okay, while Steve's thinking about that, I think, I mean, I sort of get the question, will it fundamentally change how advertising is done? I mean, I think there's more challenges are required in this area. This was just one, the Meta decision was just one of those decisions where advertising and particularly behavioral advertising and profiling has been challenged. But I think there's more to be done in this space, particularly when it comes to the Information Commissioner. Whenever we're going onto websites where we're being asked to consent to the use of cookies, and once we've done that, they want to rely on legitimate interests. And so the advertising sector as a whole certainly needs regulation and needs the Commissioner and others to really step in, because I think it's gone over the amount of information that is gathered about us. It's used, it's shared, we're being profiled. I and other commentators have said it's not enough has been done. So hopefully this is the start of it. My point is, Steve, yeah. Do you want to say any, or come back on that, Steve, since you're online now?
I don't know if we can hear you, Steve.
Okay, another question from Steve whilst he's thinking about that one. How do you think the new DP bill will affect our adequacy with the EU? Okay, let's park that one for now, Steve, if you don't mind, because let me just talk about the bill and then maybe you can make your own decision. Is that okay? Yeah. Shall we crack on then, Iram? Is that okay?
Yep, I don't think Steve's audio is working. That's okay, Steve.
Yeah. Okay, wonderful. So let's go back to, yes, the Data Protection and Digital Information Bill. We had the bill number 1, if you remember, that was scrapped. Rishi Sunak came to power, or was anointed, or whatever the term is now for a Conservative Prime Minister to take over without a without any election. I don't know what the term is. Type your answer into the chat function. But anyway, Michelle Donaldson took over from Nadine Dorries. You remember Nadine? Yeah. Had to be dragged kicking and screaming out of the House of Commons, in a metaphorical sense. Michelle Donaldson took over as Secretary of State for Digital Culture, Media and Sport, addressed the Conservative Party in 2022, September, I think it was, outlining her plans in particular for the GDPR. She said that she wanted to get rid of all this red tape. She wanted to simplify. She wanted a tailored, business-friendly British system of data protection. Yes, because the previous one wasn't British, was it, folks? It was, well, it did say UK GDPR on it, but we were involved in producing it, in drafting it, etc. But that wasn't good enough for her. She said that one that protects the consumer, protects adequacy, increases the trade in goods and in good data protection, whilst increasing productivity and avoiding the pitfalls of a one-size-fits-all system. It's time we seize this post-Brexit opportunity fully and unleash the full growth potential of British business. You're all supposed to say hooray or hurrah. Yes. But does it actually, do the proposals actually do what she's saying? Well, let's have a look then. This was the idea. This is what her plans are. She wants to regulate in these areas. Okay, interesting, her speech. She said, no longer will our businesses be shackled by unnecessary red tape. At the moment, even though we have shortages of electricians and plumbers, GDPR ties them in knots with clunky bureaucracy. So Neil, I know you're online. If you were wondering, Neil, why your plumber didn't turn up, it was because he was reviewing his privacy notice. Yeah, that's what Michelle Donald's on about. But no longer, folks, because soon we will have our own personalized legislation, which will have a, hopefully, which will lead to sort of more business-friendly regulation. So let's have a look. This is the idea: reduces barriers, reduces burdens on business, etc., delivers better services, reforms the Information Commissioner's Office. Now, in the time available, obviously, can't go through every single change, but I'm going to pick out the key ones, and then, of course, you can also pipe in and tell me if you're interested in any others, and I can talk about those as well. Just conscious of the time as well. We've got about 25 minutes. So, legitimate interest then. This is one of the main changes within the legislation. At the moment, Article 6, I think is paragraph F, where the processing, it's a legal condition, where the processing is necessary for the purpose of the legitimate interests of the data controller or some other person, as long as, and I'm paraphrasing, it does not have an impact on the rights and freedoms of the individual, or the need to process the data for legitimate interests outweighs the impact on the individual. It's a balancing exercise. In other words, you should do a legitimate interest test. Okay, so what's wrong with that? Nothing really wrong with that, but the government says in terms of having to do this legitimate interest test in every situation, they have decided to produce a list of recognized legitimate interests where there is no need to do a legitimate interest balancing exercise, as which we are used to. And in fact, I think there's a template on the Commission's website, legitimate interest assessment. So where you're relying on legitimate interest to process personal data, And those interests are set out on the left-hand side: national security, public security, defense, preventing crime, safeguarding, democratic engagement. There is no need to do a legitimate interest balancing exercise. You can just go ahead and process the data based on those legitimate interests. It also gives other examples and adds other examples of legitimate interest where you still have to do a balancing exercise: direct marketing, transferring data within the organization, ensuring the security of the network and information systems, as examples within the legislation. So does that really make your job any easier when it comes to claiming legitimate interests? My argument is, well, these are already in a way recognized legitimate interests, and even if you do at the moment still have to do a balancing exercise, usually it will be quite straightforward, because obviously national security means that you can do a lot more with an individual's information, even though it may have an impact on them. These are all recognized already, even though they're not in the legislation. Of course, we're going to share information on the basis of legitimate interest for the purpose of public security or defense or emergency. So I don't think they're giving you that much, but they make it out as though, oh, we're going to reduce the red tape and reduce the burden on organizations. I don't know. I'll let you decide, but that is a key change. Okay, let's go on to look at vexatious requests. Okay, at the moment, if an individual, when you are faced with an individual who is making a request, you can refuse. Obviously, you've got the grounds within Prevention Protection of Schedule 2 to 4 of the Data Protection Act 2018. But you can also refuse. You can refuse on other grounds as well. Refuse to deal with a request for information, or indeed any other sort of right. What is the terminology? What condition has to be satisfied? That the request is, does anybody know? Type your answer into the chat function. Manifestly unfounded or excessive. Absolutely, yes. Manifestly unfounded or excessive is the term at the moment, which is quite straightforward. We all know what manifestly unfounded excessive is, because the Information Commissioner has produced guidance to explain where somebody is inundating you with requests, they're using language which is not appropriate, their purpose is not to receive the information, but it's actually to make a nuisance of themselves, amongst other things, where they are, the volume, the language, the frequency, etc., can be used to decide that they are being manifestly unfounded or excessive. That's going to change. They're going to change that to vexatious or excessive. So where it's vexatious or excessive, you'll be able to charge a fee or refuse a request, as you are at the moment, but we're using at the moment the term manifestly unfounded or excessive. Okay, when can you decide whether a request is vexatious or excessive? It must be determined having regard to the circumstances, including, now this time in the bill, if it goes through, it will change the wording. It will add additional wording to give you sets out clearly what you can consider: the nature of the request, the relationship between the data subject, the resources available to the controller. Now that's a new one. The resources available to you. Small parish council as opposed to a large conglomerate. They will take that into account in deciding whether somebody's being vexatious or excessive. The extent to which it's a repeated request, how long ago any previous request was made, whether the request overlaps with other requests. So this is all guidance at the moment, and it's within case law as well. But really case law under FOI, but we can still use the same reasoning. But this will now be enshrined within the GDPR. Examples of requests that may be vexatious, again, this will be now included within the GDPR. Those intended to cause distress, those that are not made in good faith, those that are an abuse of process. So once again, you might think, well, it goes further than the legislation. Yes, it does, but all it does is it enshrines current guidance and case law into the legislation. Okay, just looking at Okay, let's move on then. Let's look at the government's made a big thing about cutting red tape and cutting bureaucracy. What do they mean by that? Well, some have said, well, the requirements for the ROPA aren't so stringent. Well, let's have a look at Article 30 and how that's going to change as a result of the bill. So Article 30 at the moment, organisations have to produce a record of processing activity, unless, of course, you have, is it less than 150 employees? I think that's the requirement, isn't it? Yeah. Okay. So records of processing activity, each controller or their representative shall maintain a record of processing activity containing name, processing, description of the categories, transfers, recipients, etc., etc. Okay, there's now a slimmed down requirement. Record of processing of personal data, Article 30A. Paragraph 2, 4, 8 and 9 apply to a controller that carries out processing of personal data, which, taking into account the nature, scope, context and purpose of processing, is likely to result in a high risk to the rights and freedoms of individuals. So no longer does everybody have to produce a record of processing activity. It's only those who are going to be doing processing which is likely to result in a high risk to the individual. What is high risk? The guidance is it's the same as before. So, for example, you're doing automated decision making and profiling on large scale processing of special category data, innovative technology, etc. The Commission has produced guidance and a set of criteria. If you fulfill 2 of those criteria, you're doing high risk processing. And then it goes on to give you a more slimmed down requirement to produce still a record of processing activity, but as I say, not everybody has to produce one. It's only if you are processing the data and it's high risk, that's when you have to do that. Yeah. 250 employees, is it, Neil? Not 150. Yep, thank you for that. Thank you, Iram, as well. So, slim down requirement when it comes to record of processing activity, and not everybody has to produce one. It's only if you're processing data which is your processing is likely to result in a high risk. Okay, and then one more when it comes to data protection officers then. Okay, let's look at the requirements for data protection officers. Previously, remind me, when did you have to, at the moment, when do you have to have a data protection officer? Any thoughts, anyone? Of course, when you're a public authority, you have to have a data protection officer. Let me remind you. Okay, Article 30, what is it now? Article 37. Public body, core activities of the controller process consists of operations which involve regular and systematic monitoring of data subjects on a large scale, where your core activities consist of processing on a large scale of special categories data. Article 37. Yes, thank you, Mark. Okay, so some good news for some of you here. It gets rid of Article 37, and we have a new article and a new requirement. What is the new title of the data protection officer? Does anybody know? Jeanette is typing. Senior responsible individual. Okay, a senior responsible individual is the new title of the data protection. Well, you could say it's the new title of the data protection officer, or it's getting rid of the data protection officer. Senior responsible individual, they must be part of the senior management team, I think it says somewhere. I'm just trying to find the provisions. Here we go. A controller or processor must support its senior responsible individual. Article 27 is what we're looking at. Article 27A to be precise. You have to have a senior responsible individual if you are a public body, okay? Public body, public authority, or you're carrying out personal data, which is likely to result in the high risk to the rights and freedoms of individuals, okay? You have to designate one individual to be the senior responsible individual. They must be part of your senior management team. At the moment, there is no requirement for the DPO to be part of the senior management team. So that's a change. And the controller or processor may designate 2 or more individuals to act jointly as the senior responsible individual. That's fine. You must publish their details. Senior management, what does it mean? They have to be part of the senior management team in relation to an organization. It means the individuals who play significant roles in the making of decisions about how the whole or a substantial part of its activities are to be managed or organized. In terms of the task of the senior responsible individual, monitoring compliance, well, that was the case with the DPO, ensuring the controller develops, implements and reviews and updates measures, informs and advises the controller. Something that wasn't in the legislation previously, I don't believe, organizing training for employees of the controller who carry out processing of personal data. Deals with complaints, deals with personal data breaches, cooperates with the commissioner, acts as the point of contact. So how different is this senior responsible officer, responsible individual, to the current post of the data protection officer? Do you see any differences? Do you see any problems? I mean, over to you. Any thoughts, anyone? Type your responses into the chat function. Could the existing CSIRO, asks Angela, become the SRO? If they are part of the senior management team, as it says within the legislation, I don't see why not, Angela, as long as they can, they have the expertise to be able to carry out the tasks set out within the legislation. Angela, you say removal of the DPO seems to be going full circle, back to having a senior responsible individual, which unfortunately used to be a random, okay, interesting. With minimal knowledge of data protection. Yes, some have said that if you're going to senior management team, well, if they're senior management, they're not going to have time to know and learn and keep abreast of developments in this area. Of course, it says elsewhere they can delegate certain tasks, but yes, it then becomes a figurehead again, doesn't it? So we are coming full circle. Jane, it's a fair point. Could it be a conflict of interest? Well, it depends what else they are as part of the senior management team, what else they are responsible for. If they're responsible for delivering an IT project or an innovative new project on time, on budget, and also they're in charge of the data protection compliance side of things, are they going to be cutting corners? That's a fair point. Yes, they will probably need a DPO person to advise them, Mark, absolutely, because it doesn't really say they have to have expertise. Previously, in terms of the DPO, certainly the Article 29 Working Party guidance did talk about having the expertise to be able to advise. Okay, Sarah, I'll come back to your question. I take on board your point, Steve, about the removal of the independence. Yeah, it's no longer there, is it? Yeah. Okay, a couple of other things. There's DPIAs, I think more of a cut down version. I don't think they call them DPIAs anymore within the bill. I think it's called something else, some kind of assessment. Data subject complaints, I've read elsewhere within the legislation that it will build in a requirement for an individual to make a complaint to the data controller before they can make a complaint to the information commissioner. So that's a change similar to FOI. So you will have to have some kind of internal review, internal process. And of course, there is the reform of the information commissioner. The information commissioner will be part of the information commission with a chief executive. I suspect that will be the current commissioner. But also, interestingly, it makes it a legal requirement for the commissioner for the chief executive commissioner, call it what you like, information commissioner, to have in mind the government's sort of priorities in terms of innovation, in terms of reducing red tape, etc., etc. So it sort of builds in almost, some have argued that it sort of takes away the independence of the information commissioner. And if you've seen recent sort of pronouncements and recent decisions of the commissioner, you think they've already started to, well, stop thinking for themselves and doing more of the government's bidding. I'm thinking particularly in terms of their decision around Face Watch, their decision to introduce more reprimands rather than fines, etc. Are they doing more of the government's bidding in line with what the DP bill is going to require them to do? I'll just leave that there for you to think about. Okay. Okay, think of some questions for me. In terms of changes to PECA, very quickly, let's have a look at the title. I've got 7 minutes left. Changes to PECA, the rules in relation to cookies are going to change as well. They will extend the soft opt-in to political parties, charities, and other non-profits. So the soft opt-in, I'm sure you're aware of that. That's where an individual, they sign up to a service or they show some interest in something and their details are collected. Then subsequently you can mark, and if their consent is, they give their consent, you can also market other similar goods or services to them without going back to them for consent, as long as you give them the chance to opt out. So they're going to extend that, surprise, surprise, to political parties as well as charities and others. The biggest change in terms of PECA is, if this bill goes through, the fines for breaches of PECA. What's the maximum fine for a breach of PECA at the moment? Privacy and Electronic Communications Regulations covers cookies as well as direct marketing by email, phone, text message, etc. Maximum fine, thank you, Marks, it's £500,000. That will be increased to UK GDPR levels. So 17.5 million pounds, 4% of gross annual turnover, etc., etc. I mentioned the commission. Just before we finish, somebody asked the question with regards to how will this affect adequacy, okay? Because remember, the EU, the adequacy decision in relation to the UK, at the moment they've said the UK is adequate. 2 years' time or so, it will have to be reviewed. Will these changes, are they fundamental enough for us to worry about the EU withdrawing adequacy? What do you think, folks? Type your answer into the chat function. Do you think it's going to have an impact on adequacy, or do you think this is all just a little bit of tinkering around the edges? Thanks, Neil. James says, don't think so. Penny says no. Some people are a little bit worried. Okay, I'll let more people think about that and give me an answer. Do you think it's going to affect adequacy, or is it tinkering around the edges? Okay, is there anything fundamental that they have changed which is going to make Europe worry that if we send our citizens' data over there, then their privacy is going to be violated? Okay, let's think about that one. Of course, I do agree, though, Janet, that somebody like Mike Schrems may well have a go. In fact, when John Edwards went to the European Parliament, some of the MEPs said that if this bill goes through, then it will have a big impact on the independence of the regulator, which is something else that they consider when they're considering adequacy. Okay, have a look at our blog at nowtraining.blog, and I've done a number of articles on these various decisions and the DP bill as well. Just before I finish, quick plug for various workshops that we do. Have a look at our website at now.org.uk. We've got a full workshop on the data protection bill with my colleague Robert Bateman, one of our associates, and we have various certificate courses as well, practitioner all the way through to intermediate. Those of you who are quite experienced, we've got an advanced certificate as well. Before I go, if we have time, if Iram allows me, then I think I've got 5 minutes, Iram, have I not? Can I do my...
You have got 5 minutes, yes.
Fantastic, okay. Just to make sure everybody's been paying attention, or or not, as the case may be. Some of these you will already have the answers to. Others, well, I'll let you guess because you are data protection professionals, always with your finger on the data protection pulse in terms of what's happening at the Commissioner's office in terms of enforcement action and fines, etc. So this is where I would normally, at the IRMS conference, I would put my Brucey mask on. Unfortunately, it's not with me today. So are you ready to play Aknow's version of Play Your Cards Right, folks? Give me a thumbs up or say yay.
Yay.
Okay, fantastic. Thank you, Iram. Brilliant. Okay, let's go then. This is our version. Now then, we have 4 cards. Each of these cards represents a fine issued by the Information Commissioner. So I'll give you the first one, and then you have to guess whether the next fine or the next card is higher or lower. Yep. Okay, let's go then. The first card is a 2 of, whatever that is, 2 of spades, I think it is. Okay, this represents the Cabinet Office fine. Do you remember the Cabinet Office were fined for the publishing the New Year's Honours List? And in that they had the people's names as well as addresses as well. They were initially fined, I think it was £500,000, but it was reduced to £50,000. So that's our first fine, folks. Okay, what do we think then? The next fine represents the Ticket Master fine. Okay, so the first fine, Cabinet Office, £50,000, represented by the 2 of spades. The second fine is the Ticket Master fine. Do you think the Ticket Master fine was higher or lower than the Cabinet Office fine? What do we think, folks? Let's see. Iram thinks it was higher. Janet says higher. Rhonda says higher. Oh, lots of you are saying higher, so let's have a look. Yes, it was actually higher. It was £1.25 million. Now we've got a middle card here now, so it gets a bit more exciting. So that 5 of hearts represents the Ticketmaster fine. So the next fine is the Clearview fine, folks. Clearview, do you remember? Clearview, the world's most advanced facial recognition software. They were fined by the Information Commissioner. The question is, was it higher or lower than the Ticketmaster fine? What do we think? Oh, Sonia thinks it was lower. Who else? Anybody? Most of you thinking it was higher. Are you sure, Sonia? Do you want to go lower or higher, Sonia? Okay, let's have a look then. Most of you are thinking higher. Let's see. It was actually higher. Anybody know how much the fine was? Yes, whoop, Angela. How much was the fine then for a Brucey bonus? £7.5 million. Thank you, James, Haley, Nick, and Georgina. Now then, finally, Clearview, £7.5 million. The TikTok fine, folks. The TikTok fine. What do you think? Higher or lower? TikTok. Angela says higher. Most people are going for higher. Let's have a look. For a Brucey bonus, here we go. It was actually higher. Yes, £12.7 million. Excellent. You all got maximum points. And normally, if we were in a face-to-face setting, then what would points make? You're all too young.
Prizes.
Prizes. Fantastic. Okay. Thank you very much for listening and taking part and being interactive. Have a look at the website, and if you want the slides, happy to provide those. Just send me an email or just get in touch via social media, etc. And if you've got any questions, once again, you know where I am. So thank you very much, and thank you to Iram as well.
Thanks, Ibrahim. Thank you for Aknow's training session on GDPR. It was really informative. Had a lot of fun. I hope you all enjoyed it too, and I'll see you all next time. Have a great rest of the day. Bye, everyone.
Thank you. Bye.